started.
Things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming or?
No, we're not homosexual, but we are willing to learn.
But I do wonder, for others, in other cases, whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you. You started writing your opinions.
And it just makes me wonder, you're dead, bitch. You know, why are you doing this to this poor guy?
I don't care. I'm a libertarian. What I'm getting is,
Did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you. that
Motherfucker. And I had it muted. I had it muted again. I knew it. Welcome everybody. I'm one of these days. I have to. Something's going on, and then I got to complain about it. Welcome everybody. Happy Thanksgiving. Hope the day after Thanksgiving's good. We're cracking one open here. It's been that kind of a week. Welcome. This is Tyler Yonke, LPR. I hope you enjoyed the open because we've got some things planned. Some people say, Tyler, you should plan your show. You should actually prepare. And today I've prepared, so I hope we're a little bit better off. Let's go right to the chat though. Let's see how everyone's doing out there. Muted, too loud, LOL. Hey Matt, what's too loud? My mute? Let's get rid of that music. Okay, well, here we are. Here's the plan for today. Let me walk through this plan today. We've got Nick Rekieta, okay? And I gave you a little, and there's going to be some never before released videos, okay? One of them you just saw there, Scarface, that's referenced. I can't believe that's referenced in the pleadings, the memorandum in support of motion. Motion to what? We're going to talk about all this kind of stuff. And so we're going to talk about Nick, his settlement. I did a brief update about that earlier in this week. The settlement conference. We'll go through that. He's going to have a new one. Is he going to plead out? I don't know. Kayla's motion. I think that is fantastic. We are going to go through it, and they're working in conjunction with each other. So it's not like I don't know what's going on, but it's going to be great to see. We'll walk through that. We're going to compare it with actually the affidavit because they referenced some stuff in there. And so, I actually did a little bit of work and kind of looked at the affidavit, but we'll walk through that together. What else? We got Aaron. Will his case be dismissed? Uncivil law thinks it will be, and I have a counter to that. I don't think he might not be wrong. He's just speculating, but I have some speculation as well. A little insight. Barnes, and then Mailbag and Barnes, and I talked about it last time. I did find the article. Let me just say here, I make corrections when I need to make corrections. I was emphasizing, and I kind of talked about this, and I fell into a little bit of a trap of being a little bit lazy, okay? Which is, Barnes did not represent Sandman, okay? He represented Covington kids, okay? And then people were saying I was being deceitful. Was I? I think he was being deceitful, saying that he was representing Covington kids, which he was, but he was he was implying that he was representing Sandman. So there's some, maybe some blame to go around there for everybody. Okay. So yeah, Rekieta's turned out to be some real strange folks. Yeah. Were they implying he was doing some home renovation? Yes, maybe. Motion to squish. I wonder what y'all's drywall is like. Hey, by the way, I just did a flooring in my daughter's room. She's moved out, so it's like a guest room. And I'd finished flooring in the whole house last year, and I wasn't sure what to do in there. We decided, okay, we're going to do the same flooring. So I did it. And to go in there, and then I'm like, okay, if you're going to do this right, you're going to do it right. Tear up the carpet. I had to put subfloors in, and then there were some places where it's on the first level, and the second level above had done some leaking in the bathroom. So anyway, some of the drywall had a little bit of mold. So I cut it all out, and it was just a touch there. So I was doing drywall. And I'm pretty handy with that. And once you figure out that you can put holes in walls and fix them pretty easy, put new drywall in, spackle it up, got to texturize it and then paint it and whatnot. So I could do all that kind of stuff. And I often move put up a big TV in the living room, and you run cables up the wall and you submit, So anyway, I could do all those kind of things. I don't know that Nick can do those kind of things. So do you surmise, and we'll get there. Barnes claimed he was yes, Maddie B, you are completely right. So I haven't even read the comments. I just saw one. Someone said, I've now subscribed to Barnes thinking, I'm like, fine. I don't care. I was watching a podcast today. It was Pete Quinones. He was talking to Tom Lugano. And he said, I'd had a falling out with Robert Barnes. He blocked me. And I'm like, yeah, he does that with a lot of people. Not with those spaghetti shoulders and Nick's. Yep, you don't have to be a man, a big, strong man to be handy. But he's handsy. But you can figure shit out. I build stuff. I'm not the best at it. I'm definitely not the precision carpenter guy, but I can make do with everything. So, okay, anyway, I hope everyone's having a great time out there now that we're not muted. Damn it. One more time, Tyler. Okay, let's take a look. There we go. There is and I'll try to get to you. It was like, if you can replace sink doors, y'all ain't drywall. Sink. I don't know what you mean by sink doors. I do drywall. It's not difficult. Anyway, we're not going to really talk about this, but I'll show you pictures. I did some work. Okay, so here's a confusing part to me. Now, I don't do criminal work, but I do civil work, and you use the title your motion, what it's for. What do they call it? A PIRAC or IRAC for if you're law students. Issue, rule, analysis, conclusion. That's kind of how you do it. And some do PIRAC, which is problem, issue. Fine, okay. But in your heading here, you want to pretty much say what your request to do. Memorandum. It says memorandum for Kayla, Christine, Rekieta. Memorandum in support of motion. Motion to what? What's your motion? I don't know. It'll be interesting because nowhere in this document do they talk about what her motion is. They imply it, that the warrant's not valid. And then they do this conclusion. For this reason, the defendant's motion must be granted. Motion to what? Motion to what? I don't know. That's why, earlier in the week, I did a little bit of a show and I was like, yeah, the motion to quash the warrant, set aside. I don't know what it is. I still don't know what it is. They're saying the warrant's not valid, but what is the motion to do? Okay, I guess that's what it is. I just like clarity, okay? And sometimes it's good to, it'll be interesting. So as an example, you go into a hearing and you've made a motion for something, and that is the only thing that's at issue typically when you go into that hearing. And you got to be specific, plead in particularity. And if you're trying to talk about something else that hasn't been pled, I get it. Anyway, I don't know. Maybe I'm reaching on this one, but it just was a little bit confusing to me. Okay, let's walk through this because I've got some stuff, and with it, I have breaking video. We will get to. It should be fantastic. I think I have it right in here. Should I get to this one first? No, let's go here. Okay, to the above named court, the state and their attorney, Kristen Pierce. This matter came before the court for I want to do something here. I was going to do it, pop-out chat, but that's not going to work. Kandiyohi County Courthouse, Wilmar, Minnesota. Shane Baker, Kandiyohi County Attorney, appeared for and on behalf of the state of Minnesota. Maggie Kluver appeared for and on behalf of Ms. Rekieta. Okay, that was from the omnibus hearing on the 28th. No testimony was offered at the hearing. The state offered the application for search warrant and receipt inventory in return without objection by the defense. That's just, okay. Facts of the case. May 22, and we know these, but these are interesting. So I don't know that just because they're stating the facts that these are not stipulated to. So it's just facts as Pomplin has had them, and it's not necessarily facts as Kayla is going to, because some of these she would probably argue that they aren't facts, but it's what it is. May 22, Deputy Pomplin. Now it's deputy. Remember before it was, I don't remember. They kept saying deputy and then investigator or something. There was confusion there. With the Kandiyohi County Sheriff's Office applied for and obtained a warrant to search defendant Kayla Rekieta's Kandiyohi County, Minnesota home, where she shares with her husband, Nicholas Rekieta, and their 5 children. In addition, the warrant granted the sheriff's office the ability to search Nicholas's person. Okay, now look, people, we've been over this. You probably watched a bunch of different people do an analysis. I've got some input here you're going to want to just hang on for, okay? You're going to want to, allegations contained in the application for search warrant were as follows. These are the allegations. Okay, so that makes sense. An unidentified reporter heard the following rumors about the Rekieta from the other people in the church. Now, I don't know if it was unidentified, I guess, in the application itself, but I think we've subsequently come to know who that is. There were concerns about neglect of the children, possible controlled substance use, and a questionable relationship with an additional couple, Aaron and April Imholte, a married couple. The Imholtes, I don't know how you say your name, Imhotep, may have been staying at the Rekietas. The home was in disarray and clutter. The children were hungry, not fed, wearing clothing multiple days in a row and started smelling. Nicholas appeared lethargic and high or drugged while driving a car around. Hey-o. Nicholas walked out randomly on sermons and exhibiting behavioral changes. Kayla looks anorexic, and Nicholas has recently lost weight. Yes, all of those things. Nicholas has injection or track marks on his arms, which I don't think was ever actually verified that it was maybe a scabs. But then I was trying to remember someone I was listening to do this, probably a Josh Meme Copium. He's like, if you're a druggie, you might be scratching. It's the Dave Chappelle, the guy that's always doing he's on coke. The application for a search warrant was silent on whether the unidentified reporter was a person known to law enforcement. The application for search warrant was silent on whether the unidentified reporter was a reliable source. The application for search warrant was silent on the source of the information that Nicholas and Kayla are friends with Aaron Imholte and April Imholte. Well, now April was at the house when they got there, so if you're not friendly. One of the people, I think it was Nick said no, she's not a live-in nanny, and Kayla said that she was. So you're friendly with her at least. Deputy Pomplin indicated that was personally familiar with Aaron Imholte's social media presence. Okay, what about Nick's? The application for a search warrant was silent on the source of the information that Nicholas is a social media blogger. The application for search warrant was silent on the source of the information. Well, and by the way, I hate the word blogger at this point. It's not 1990s anymore, or 2005. The application for search warrant was silent on the source of the information. Nicholas is a social media. I don't know. I think it talked about Nick doing video blogs. Matter of fact, we can actually look here. There's the Pomplin report. Let's see if we got this a little bit. There we go. I don't know if this one's searchable blog. This might not be a searchable document here. Nope. At least this one's not. Deputy Pomplin viewed blogs created by Nicholas. Okay, well, so he was obviously aware. And Aaron had made the following observations. I actually think he said that he was I missed one. The application for a search warrant was silent on the source of the information that Nicholas is known to drink alcohol excessively during video blogs. Was it? Pomplin viewed the videos by Nick and Aaron and made the following observations. There was a change in Nicholas's appearance from the January 2024 videos and the May 2024 videos, including that he appeared to have lost weight, appeared tired, and appeared, quote, strung out, unquote, consistent with controlled substance users. Nicholas's studio was in the basement of his residence. Aaron Imholte indicated that he and his wife were getting a divorce. Aaron Imholte indicated that he had experimented with drugs and some dick, I think, is what it came out with. The videos made it apparent that the Imholtes and Rekietas were friends who recently had a falling out. In Aaron Imholte's video, April Imholte appeared tired, lethargic, and strung out. Okay. And those are things you can notice, right, of someone. Nicholas and Aaron Imholte appeared in the same room during the videos. And then that's just also, you know, that it's not a studio of some sort, like a green screen, right, a different background, but it's actually there. He's actually getting wasted in his basement, da-da-da. Now, Nick and Aaron appeared in the same room during the videos. On May 22, 2024, Aaron published a video blog insinuating that Nicholas was using controlled substances and that Nicholas needs to get help and help for his children because of his substance use. And there was a video where Nicholas had a white powdery substance on his nose. I think we have a picture of that. Let's see if I could find it. Where is it? Oh, where'd it go? Where did it go? Slideshow. There you go. There's a picture of Nick with some substance on his nose. Shocker, but it happens. Okay. HI, on May 21, 2024, Nicholas put a video blog online that showed him drinking what appeared to be alcoholic beverages, in which he appeared to be under the influence of controlled substances. During the video, Nicholas leaves to use the bathroom and returns with a white powdery substance under his nose. Should we go back to that one? I don't know why I'm having so much trouble finding that actual. There we go. There you go. That's a picture of Nick coming back. Deputy Pomplin believes Nicholas was under the influence of a central nervous system stimulant. The deputy believes Nicholas ingested a substance through his navel cavity off screen. During the video, Nicholas appears to struggle to read the screen. He rambles and he has slurred speech. There is no indication contained in the application for search warrant as to what time of the video was created, whether the children were under Nicholas's care or whether there are any other adults in the home caring for the children at the time the video was created. There was a comment by Pomplin that Nick was so intoxicated he couldn't be taking care of his kids. That's just one thing, but okay. Deputy Pomplin alleges that Nicholas has been a victim of swatting and that Kandiyohi County, what kind of swatting? I know he touched, he and Aaron went, I don't know if they went penis to penis, but maybe they're swatting each other. Maybe that's a different term in a swingers club. I don't know. They do have a one here, so maybe I need to go down to the bottom to see. Let's see, we're on page 4. Let's see what it says swatting is. It doesn't give a reference to, it has a 1 next to it on page 4, indicating that there's, oh, here it is. Department of Homeland Security defines swatting as making malicious hoax calls to emergency services to report an ongoing emergency such as a violent crime or explosive device at a certain home. Well, okay. Deputy Pomplin misstates his qualifications as a DRE and that he claims to have training and experience in making evaluations of individuals with whom he has only viewed in video productions and not personally interacted. So I didn't know so they're stating here that he's lying. He's just outright lying. And by the way, we'll get to it a little bit later in some of the other stuff about Aaron. But there is a litigation privilege. Okay, you have basically an outright immunity from making defamatory of privilege for making defamatory statements while in litigation. Now that person has to be connected to the investigation, the case. Somehow you can't just be in here and then make an outrageous claim about Robert Barnes as an example. No, he has to be part of this case. So, you know, he's in a way, maybe are they saying that Pomplin, they don't give any further analysis as to what that misstatement is. You'd think you'd back that up a little bit, but whatever. Here's the analysis. The U.S. and Minnesota constitutions protect against unreasonable searches and seizures. U.S. Constitution, Amendment 4, Minnesota Constitution, that's, unreasonable search and seizure, papers, effects. Minnesota Article 1, Section 10, law enforcement may conduct a search and seizure upon securing a warrant that is supported by probable cause and issued by a neutral, detached magistrate. State v. Harris. Quote, this is a line from there. Unlike proof beyond a reasonable doubt or preponderance of an evidence, probable cause requires only a probability or substantial chance of criminal activity, not an actual showing of such activity. So, by the way, and I pulled up all these cases. We can, if you really wanted to, we can take a look here. Here's State v. State v. Minnesota. That's what they're stating here. The issue that you're really talking about with the, you know, what they're doing here, though, they're outright saying the correct standards, which you only have to have a not actual showing of such activity. So this is a quote and case citing that's not necessarily in their favor, but they're just actually, once again, problem, rule, analysis, the conclusion, or issue. So they're actually, you know, going through these steps, making those what the actual is. Harris at 7, quoting Illinois v. Gates. So I looked at that case as well. It's a Fourth Amendment standard review case. There you go. Let me see. I did have some notes. Let's see if I have any on State v. Harris. Okay, this is important, which they don't bring up here, which is under State v. Harris, and we've talked about this when the warrant was first coming to light, which is it's a totality of the circumstances. Now they do reference State v. Harris here, and then they reference Illinois v. Gates. And those are big on the totality of the circumstances, okay? So you don't just take one aspect, and then they talk about de novo review, which is for an appeal. You don't take one item if it's, you know, okay, maybe Pomplin didn't have his correct DRE or whatever that is, his learning, you know, and education to notice drug seals. Maybe he misstated the one certificate that he did have. You have to look at it. You can't micromanage each one. You can't do what's de novo, you know, bit by bit. It's actually, you've got to take it all in its totality as well for the review. So they don't mention that in there, but you know, it's not to their liking. So that's what I would say on the opposing side. You're going to reference, okay, yeah, it's, you know, such showing a criminality, but we're also talking the totality of the circumstances here. The task of issuing judge charged with determining whether probable cause to search exists is simply to make a practical, common sense decision whether, given all the circumstances set forth in the affidavit before him, including the veracity and basis of knowledge of persons supplying hearsay information, which you can do, there's a fair probability that contraband or evidence of crime will be found in a particular place. Harris at quoting Gates. So yeah, there has to be a fair probability. And by the way, so I don't know, they're bringing it up. They're laying out the case here. It's perfectly fine. So far, so good. So far, they've given me nothing to push back on, other than they're stated that Pomplin lied. Essentially, when I read there, it sounds like they're saying he lied about his qualifications to recognize druggies. But look, can you recognize one? The affidavit must be sufficiently detailed and include all of the evidence law enforcement has that supports probable cause to believe that items sought are at the location to be searched. I don't know what 11 is because there's no, maybe it's a typo, or maybe it's, no, they're not even quoting the case. And they must describe with particularity the things to be seized. Sorry about that, I got dogs in here. Affidavits must not be conclusory. And we've talked about that before, conclusory, declarative type statements, basically not supporting, you know, this is, and we'll talk about this in a bit here. Let's just keep going here. Conclusory, as you can understand, is just a statement that it makes a conclusion without backing itself up, but should detail the underlying circumstances that supports the affiant's belief that there is probable cause. Aguilar v. Texas. So look that one up. We also have Aguilar v. Texas here if you want. We can, we don't really need to read these cases, but as a case in 1964, still valid today. Yeah, so there we go, PDFs. Okay, so what, let me take a look here. What these fucking dogs. Probable cause did not exist. Conclusory statements and inference of the crime. Yeah, so that's pretty much what that case stated there. Let's keep going. Sufficiently detailed recital. There's a quote from here. Recital of some of the underlying circumstances in the affidavit is essential if the court is to perform its detached function and not serve merely as a rubber stamp for the police. State v. Anderson. See also State v. I'm gonna fucking kill those dogs. So let me just break this down to you, okay? So my daughter came home. She has a big dog, and that doesn't get along with the dog that we have here. So we have to separate them, right? 3 of them are up here, 1's down there, and then we end up swapping them out, and it's a pain in the ass. And I'm about had it. I about had it up to here with it, because they should all just be able to run free as they want. Dog door, outside, whatever. But with the other dog too, we have to be careful because she's not so good about being around chickens. All right, if the magistrate is to perform his neutral and detached function and not serve merely as a representative for the police, then the magistrate must be provided with more than mere opinions, conclusions, or beliefs of the affiant. Yeah, so they're basically saying that they're laying out this case, which is conclusory statements. You can't have conclusory statements. You need more than just opinions, beliefs, conclusions on yourself to do this. You need facts that go along with this. And that's really what they're breaking this down, which is a good argument. It's really the only one that they have at this point, okay? And they're going to bring to light this. So just hang on. If you didn't know, the information reported to law enforcement has no indicia of reliability. Okay, but remember, they've got to break this down across the board, that the entire warrant, all the info that was given, because on a review period, it can't be, once we said, de novo. It's got to be, everything has to be, on the up and up. I mean, on the down and down with them. The information in the affidavit can come from various sources, including eyewitness testimony, informants, or surveillance. However, for the warrant to be valid, the sources must be reliable. Once again, State v. Givens. If an informant is used, the affidavit must usually demonstrate that the informant has previously provided reliable information other than the independent sources corroborate their information. I didn't look that one up specifically because previously supported good information. I don't know that you're going to necessarily have it. Now, the question is this an informant, like a criminal, police informant that you would have, or is this just a witness? Okay, I don't know if they're conflating the two here. So I don't think I actually looked up Givens, so I didn't look up that case. And I would be interested because it'd be my surmising here that they are inferring that all the witnesses are in fact informants. Okay, an informant is a little bit, and it talks about previously provided information. Okay, this is your person that your confidential informant that the police have. This is really a criminal person. Not an enterprise, but like a criminal person in the first place. Okay, someone that gives you information quite often. They're on the street. They're doing that. That's not what we're looking at here. Okay, maybe I should just actually look it up because I think that's probably where they're at, and it's probably not at all what the situation is. We're just talking about a witness. So if a witness sees something and they're going to report it to the police, as Kayla's attorneys here, they're trying to infer this here that this person has had to have given reliable information in the past to corroborate, but that's not necessarily going to be the case. Okay, from just a witness. In our case, the affiant does not even bother to recite the source of much of the information. No mention is made of whether the information was from a reliable or identifiable informant. I don't think he called them informants, though. The report to disclosure does not reflect that the anonymous reporter possessed firsthand knowledge of the allegations. Moreover, the information, we can have hearsay, but hearsay is part of it. You don't have to, you just quoted that on the initial, was it Gates, I think case, Aguilar even, that hearsay is appropriate, is fine. Reported this guy moreover, the information reported was not corroborated by the independent facts or verified through further investigation. Well, I don't know about that. He did start off with the letter and then went from there. In addition, the reported information is made even more suspect by the fact that Nicholas is a well-known internet personality and has been the victim of swatting. Okay. I mean, that does take into it. What you don't see is Tim Pool, by the way. He's one person that's been swatted a bunch, okay? And I think every time the police take it serious, okay? Because it could be an issue. And if they don't take it serious and then something happens, now the police are not there to actually protect and serve. They're there to collect your money and take you into jail, just so you know that. There's been quite a few cases on that. They don't have a duty to protect and serve. So when you see that on the side of their cars, that's bullshit. There's been up to the Supreme Court. Castle Rock v. Garcia, I want to say that's the kind of big one where this had a restraining order against this guy and threats against her and police. Anyway, she was calling the police, whatnot. He ended up killing her, and then they or hurting her. I don't remember all the details. It's pretty gruesome though. And so there's a lawsuit and went up to the Supreme Court. Should the police be liable in this? And they're like, no, they don't have a duty to protect you. So, you know, swatting is going to happen. And do the police have to take those things seriously each time? Well, they think criminal activity is going on. So likely, you know, does that mean that then you don't go out to Nick's place? I don't know. Where are we at here? Swatting activity likely initiated by Aaron, who has recent falling out with the Rekietas. See, so here it is. In addition, a well-known personality has been a victim of recent swatting, likely initiated by Aaron Imholte. So is that defamatory? Oops, it keeps going bigger here. That's what she said. So maybe we'll take a look here at what Aaron has to say about the swatting, because he made a comment about it. And I'm curious as to what Aaron is going to say about le swatting. Let's go here, talk about it. Playback speed, we'll go 1.25. All right, let's go.
Okay, so this is real, but I can't say much about it.
Okay.
Well, I can't say where it came from. Nicholas, this is about Nick. Nicholas, a well-known internet personality, has been the victim of recent swatting activity, likely initiated by Aaron Imholte, who has a recent falling out with the Rekietas.
Okay, I don't like the way he pronounces that name. Imholte? Is that how you're gonna do it? Is that how you're doing it to me, Aaron? That's how you pronounce your name, Tyler Yonke?
Is that actionable? Should I be calling an attorney about that?
No, it's not, and we'll talk about that in a minute.
Possibly if they're saying that you
likely initiated. I don't know their address.
And plus, like,
okay, he's been to the house a bunch. Okay, he was living there. Does he not know? And he's pulled it up on their Google map. It could be. I mean, there are people. I get this way, which especially when I'm out. I moved to a place or been there for a while, and I get to know it by just driving around or riding my bike. I don't necessarily remember the streets. I know my street here, but sometimes I just don't know. So I don't necessarily know the addresses to like my friends. And then you put it in your phone and you just go. So I can believe that, but I mean, he would need to maybe clarify that a little bit. Like, sure, I've been there a bunch, but I don't know the physical address. Well, that doesn't mean you can't swat him.
Wow.
What would you do to initiate?
Wow, that's in horseshit.
All right, denying it.
Yeah, Death Beholden says they didn't even say allegedly. Zenman Build says, yeah, I'd be calling a lawyer.
Well, they do say likely. They don't accuse you specifically, but
likely.
They say it's highly probable or likely. So I don't know if that's
and plus
necessarily.
Nick whinging and bitching about. So I mean, I'm not going to be able to prove that takes money out of my pocket.
Right.
You know. Wow. That's you know what it is? It's pathetic and it's low, and it really shows kind of just a lack of taking responsibility, and also the continued obsession with Aaron Imholte. The continued inability to let Aaron go.
I mean, in Kayla or Nick's defense here, he's part of this. They've got to have a defense. They've got to try to chip away at this I guess it's a motion to quash the war. I don't know. It says just a motion in support of what?
Unbelievable.
You know what they say? Once you go Imholte, that's where you stay.
Is that I didn't know that was the phrasing.
Yeah, apparently.
I didn't know that was it. Oh, no.
Okay, we're not going to watch the rest of this. So, but what I will do is, let's see if I can, I want that down, take that one. Okay, hang on a second. Let me pull this up because I think I have a breakdown of issues, Aaron, litigation privilege. There we go. Let's take a look at litigation privilege, and we'll talk about why this is not going to really work for him. I imagine it's in most jurisdictions. It's probably there as well. Litigation privilege is a legal doctrine that provides immunity from defamation claims for statements made during the course of litigation, including out-of-court communications. This privilege is designed to protect participants in the legal process, including attorneys, parties, and witnesses from being sued for defamation or other torts related to their statements made in furtherance of the litigation. Key principles: absolute immunity. The litigation privilege provides absolute immunity, meaning that statements made during litigation are completely shielded from defamation claims, regardless of their truth or falsity. Scope of the privilege. The privilege applies to statements made in connection with judicial proceedings, pleadings, motions. We have a motion, definitely have a motion. We don't know what it's for, but we have a motion. Discovery and trial testimony. Purpose of the privilege: litigation privilege serves to promote the administration of justice by allowing participants to speak freely and blame others for their mistakes. I added that part. And candidly about the facts and issues in the case without fear of being sued for defamation. No malice requirement, unlike other defamation privileges, such as qualified privilege. The litigation privilege does not require a showing of good faith or absence of malice. There you go. All right, so let's keep going here, and I'll get to all your questions and concerns. So he had a concern, he had a falling out, and with that, they're blaming him for swatting. And this was just, I mean, look, it's hard because we know the conclusions after the fact, right? We're really playing backseat driver. We're playing, couch quarterback or whatever it is after the game. Okay, we are running film now after the game, and you can't do that. In other words, we know the outcome. We know when they got there. There was, I mean, look, we literally have a picture of what the outcome was. Coke on the nose. So we know what the outcome is, and you know that this, but you can't do that when you're talking about the warrant, because it doesn't matter. Matter of fact, if they quash the warrant or set it aside or whatever this motion is, then you don't get to use. I mean, they're likely would have to drop the charges, right? You have nothing against Nick, so that all goes away. So with that in mind, it's still hard to read this and know the outcome and go, but hey. I mean, hey, let's be honest here. We know what you were doing, and swatting or not, there were drugs in there and their kids and blah blah blah. Okay, the facts alleged by investigating deputy are conclusory and based on pure speculation. The facts that the internet celebrity may have appeared to have lost weight, appeared tired, and appeared strung out are conclusory in nature and not factual. Now, I mean, just in that regard, yes. Okay, Nick, but it's appeared. And by the way, we'll take a look here. Maybe we'll just, let's read this and then I'll go to the affidavit. Likewise, the allegation that April appeared tired, lethargic, and strung out are mere conclusory statements that fail to recite facts leading to such conclusions. For instance, this is the age of prescription weight loss medications. Essentially, everyone is losing extraordinary amounts of weight in a short period of time. However, no independent investigation was done in that regard. Nicholas also suffers from insomnia, yet no independent investigation was done in that regard. In addition, the mere fact that Aaron Imholte posted a dubious video blog insinuating that Nicholas was using controlled substances does not make said blog factual corroborating evidence. No, but it's a totality of the circumstances. So it's all the circumstantial evidence piled up high until you have, we should play this one more time until you have this. Let's go here.
Stunning.
That's the one I wanted right there. I wanted the mountain of coke. Yeah, until you have a mountain of coke. At its best, unreliable hearsay. However, it is more likely retaliatory due to this falling out with the Rekietas. But Aaron was just one aspect of this, just one person in this cog, in this wheel. Here's Deputy. I am a licensed peace officer. Okay, make the application, known, da-da-da. He walks through this. He says, I believe, he talks about what this is the application here for the warrant, okay? What I wanted to get to was he's attended hundreds of hours of training, so they're saying that's not enough. He's certified in firearms. He's certified in these other aspects. That's great. He talks about the parties. He started to review Nick Rekieta and Imholte's social media blogs. The blogs are commonly related to legal issues and high-profile trials, as Nick is a licensed attorney. Nick is known to drink alcoholic beverages excessively on these video blogs. Remember, they said up there was at one point they mentioned that there was no. What would they actually state here? Because which page was I on here? It was on C, so we're getting right next to the conclusion, page 7. Okay, it was some of these, no indication in the application as to what time of the. Nope, that's not what it is. Sorry, I should have done much better. People, I'm just winging it. Home is in disarray. Children are hungry. Walks out of church. Application does not know. Personally familiar with Aaron's social media. Well, application was silent as to the information on Nick's social media. But didn't we just read that it said he both of their blogs? So that's not a truthful statement by them. He viewed blogs created by Nick and Aaron and made the following observations. These are allegations, right? Oh no, these are facts in the allegations. Following observations, Nicholas Studio. There was something here. I don't know. We'll keep going here. But he reviewed all of them. Nicholas is known to. Oh, it was about drinking. It was that he didn't mention anything about Nick drinking. Well, he did. He was numerous alcoholic beverages during his blogs. He immediately noted that Nicholas's parents in recent months had changed. So that's a key right there, which is remember the issue is conclusory because it appeared he had lost weight. Well, you watch these blogs, video live streams of Nick over the years and over the last 6 months, you're going to see that change. I watched one before this happened, and he's talking about his weight loss, okay? And he's trying to make it sound, it was crazy because I'm like, I fluctuate. I've been super fit and then not so much, and then I'm heading back there. So I'm always interested in people's journeys in with that. And he's talking about it. I'm like, oh, maybe getting skinny is fine if you're healthy and fit. But he's not talking about like working out. So then I was I was questioning it at that point from a person who understands these things. Kind of where you're at. So he's able to see that. I saw it. Nick was obviously, we've seen the videos there, the comparisons. He's obviously was losing weight. It was easy to do. And because you've watched numerous blogs, videos over the years, right? Or the months, noted that his appearance in recent months has changed. It's a significant change. In the videos, look at this. This is the non-conclusory part about his weight loss. He appeared to have lost weight. That's conclusory. Except for these comments. I immediately noted that Nick's appearance in recent months has changed. In videos from 2024 January compared to May 2024, he appears to have lost weight, appears tired, and overall appears strung out, in common with controlled substance users. Did we notice that? Did everyone else notice that? It was obvious to everybody that was the case. Okay, people were sending him, and by the way, he's on these video streams a long time. 4+ hours at a time at night. It's it's easy to do. Nicholas appeared to have lost weight. Strung out. Nicholas comments his studio in his own residence. Nicholas has been a victim of swatting phone calls and is known geography in Candiota County Sheriff. So they were well aware of who he was. And by the way, I doubt because it wasn't an anonymous call, right? I think Aaron. If he did report something to the police, it wasn't him doing it as an anonymous person. So a swatter usually isn't going to give him their name, right? And here's my contact info While reviewing the media blogs, Aaron recently indicated that he and April are getting a divorce. We've been over this. Is in both of their studios. His parent there in the same room. We talked about that. He did a blog and talked about Nicholas situating controlled substances. He reviewed the video taken off Nicholas's YouTube and Rumble social media sites. The video from 5/21/2024 is of Nicholas in his basement studio talking about a court of appeals ruling he lost. He appears in the video to drink alcoholic beverages, eventually appears under the influence of the substance. The entire blog is 4 hours and 4 minutes long, approximately 2:46 into it. Nick leaves the room to use the bathroom. When he returns at 2:50, he appears to be an excited look and has white powdery substance on his nose. Your affiant believes the behavior is indicative of central nervous system stimulants. Your affiant believes is based on training experience that it's the behavior of Nick, that he has ingested white powdery substance through his nasal cavity. Your affiant knows through training and experience that ingesting controlled substances through his cavity is commonly amongst controlled substance users and often referred to as okay, so he goes into snorting. Okay. Nicholas so under the influence of the substance to at one point he has to close his one eye to read the screen, rambles and slurs his speech. He would obviously not be able to care for his children in this state of intoxication. It should be noted. And then he talks about his drugs, counseling stuff, consistent, Okay, this is your affiant behavior in this blog indicates polysubstance use, meaning it is believed that he is ingesting more than one substance, both being excited and nearly passing out. This can be a consistent behavior. Okay, and that's just important. It's a little aspect there, right? Which is I'm able to observe this guy and I'm showing you he's excited and then he's almost passing out and he's lethargic. These are not necessarily conclusory because you're able to say, I've watched hours of this video based on my education. These are aspects that happen with poly use abuse. Okay, let's go here. All right, we're gonna go up to C. We're almost done, people. The investigating deputy does not possess any training or experience in determining drug recognition via video production and thus is not qualified to offer an expert opinion. Okay, so this is fascinating. The expert opinion of the investigating GRE deputy must be discounted as that opinion is based only upon the observations of the deputy while watching an internet video performance. We are getting into the performance aspect here, people. There exists no independent corroboration of any of the conclusions alleged by the deputy. There are no garbage polls. I don't know what that means. Does that mean they're going to go drag April around? Where's the laugh track for that? Okay, she's garbage. No allegations from persons that there were drugs in the Rekieta home. Actually, there were allegations. It was Aaron. Aaron said he did substance. They just referenced that above. So they reference above that Aaron was the person that was doing drugs in the home with Nick. And then they say that he's not a reliable informant. And now they're saying that there was no evidence or no testimonies of anybody saying that there were drugs in the home. Moreover, as a GRE, the deputy did not perform any testing on the defendant that would confirm his hunch. Okay, that might be the dumbest statement, right? And the reason I'm saying dumb is because what are you going to do? You're going to come up to Nick. You don't have a warrant. You don't have a warrant yet. You're going to come up to Nick, an attorney, strung out attorney, but still an attorney, okay? He didn't, by the way, when they did pull him over for the day that they were executing the warrant, he wouldn't even give him access to his house. He does know enough that he's not going to willingly give them a drug test. So you're not in garbage polls. Okay. I know what a garbage poll is, by the way. So there's no expectation of privacy of your trash cans at the end of your driveway. Okay. So if you have your driveway, your trash out there and you've put all your drug contraband out there, the police can go through your trash, but they don't want to tip Nick off for that. And do they really want to get, a possibility of getting maybe a needle stuck in a hand, digging in there? So they didn't do that, but they aren't going to test Nick before. That's ridiculous. Nick's not going to ever let that happen, likely. If the court is to follow detective's logic, the deputy could just as easily justify a search of Al Pacino's office on the set of Scarface. That is, let's give them some applause for that. The only thing you could come to the conclusion, right, from there is that they are making the claim that Nick is an actor, or this is a performance. And we do have a video, okay? I do have video proof of this. The problem is, though, Nick has never acted so, I mean, he's faking this. That's what it is. The girl under the desk or whatever, the snorting in the nose and the coke and that whole little performance was a performance, okay? Conclusion, but they don't conclude. They keep writing more arguments. The most disturbing part of the search warrant that was granted in this case was the utter lack of evidence or allegation, credible or otherwise, that there were illegal substances located in the Rekieta home, much less that there were drugs that were located within the home. The controlled substances use is not illegal in Minnesota. Possession is illegal. Yeah, but do we need to look at what these charges are? Because child endangerment is a problem. Okay, so there are no allegations. Okay, we don't know the nature of the white powdery substance alleged to be present on Nicholas Rekieta's nose, nor does the deputy. It's just as plausible that it was sheetrock dust as an illegal substance. No, it wasn't. And the reason being is because you can infer some things, right? And they laid it out in their case law here, which is you can, it has to have a leading possibility of leading to, discoverable evidence, or, that there's a crime being had here, right? And Pomplin went over all that, right? It's Aaron's comments. It's Nick's acting that he's doing in there. It's the people in the church. It's the letter to the CPS people. It's the school. It's him driving. It's the witnesses. A lot of this all leads to Nick is not doing house repairs. He's doing nose repairs, nose reconstruction. Okay, so it's a sad argument, and this is why I'm saying. They just don't. Some people have said, "Hey, this is much better written." Okay, the words put together, good, much better. Okay, but the substance of what it's saying is just bullshit. We don't know the nature. It could be anything. It could be, sheetrock dust or illegal. We don't know whether Nick's was actually consuming alcohol. Nor does the deputy. Well, I think Nick makes a big deal. He talks about his alcohol. He talks about the expensive alcohol and the liquor and whatnot. So, okay, then why is it? Then there's a problem. Nick has a mental problem then of acting this way on screen, I guess. We can't field test a video. That's so stupid. It is all speculation and conclusory statements and guesses from people who have no firsthand knowledge of the home. Okay, Nick Rekieta is an internet personality, and in a single video, the only credible evidence contained in the application for the search warrant, Nicholas Rekieta was engaged in an internet performance. It's a show for likes and hits. The more likes, comments, and hits the performance generates, the more income is generated. He is an actor. So here is a questionable situation. If you go forward, are you now putting into place Nick's financials? At the time that this video happened, they are claiming the more outrageous his conduct, the more likes, the more money he was making. Was that the case at this time? I would want to now, okay, then you know what? We're going to subpoena your financial records. We're going to find out if that's the claim. We're going to find out all the actual, and this is a problem because you're going to find out all your actual income from this. And to do so, maybe we have to look at all your bank statements, maybe all your bank accounts. And then we can maybe look and see where you're actually spending your money. Maybe there's, 20s of thousands of dollars you're doing stuff with. I don't know. Maybe it leads to more problems. So I don't know if this is going to open the door for that, but I would be really interested, as a DA that wants to really go after this. I mean, if I was doing this in family court, I'd be like, oh, sweet, thanks. Let's go down this route. Let's take a look at all your earnings right up until that moment, and what are you truly making money? I mean, it could do one thing. One, it could lead you down a different rabbit hole, or it can give you an indication that no, he was actually losing money. He was losing his mind. He was snorting his profits away, and he wasn't actually getting more likes and stuff for his outrageous behavior. Nick for income. He is an actor. That's what it says here. Kayla believes, or her attorney believes, Nick is an actor. This is insanity writ large. We all know we are not to believe what we see and hear on the internet, given the reasons provided herein and the shocking absence of any corroborated facts upholding the search. I mean, I would search warrant issue. This matter derides the entire notion of the probable cause standard itself. For this reason, defendant's motion must be granted. What's your motion for? Well, I don't know. Okay, so here's the key, people, and then we'll get to your stuff. We have a video of Nick acting. Ready to go.
Adios, arrivederci, au revoir. Take one.
Well, you know, I mean, well,
Hang on. For some reason, I'm not getting the volume here. So I want to make sure that that I am able to have it. Hang on. Okay, let's see if this will do it here.
Adios, arrivederci, au revoir. Take one. 5 cameras.
Why would you do this? Why now? Why is my camera so on? Trying to shut the show down. Like, oh, we'll play the credits. No. What we'll do is we'll sit here. Guys.
Okay, everybody, that's a wrap.
Here's credits.
Gorgeous. I hope you enjoyed that clip I made. Nick made. And you know what's interesting? In that clip, he says, roll credits. Roll credits. It's like he knew. Nick knew what was going to happen. And if we were only smart enough, we would have possibly known as well. Okay, you know what I'm going to do? I'm going to try to go back here and see some of your comments. Maybe we'll go from the bottom up. Why indeed, Nick? Why? Well, there's probably a lot that I've missed here, so I don't know if I could get to everything. But if you guys have some more, yeah, look at I like this one. Someone's telling me how to say his name. Imholte. I thought his name was Imholte too. I don't know. Imholte. Get it, Nick? Why indeed? Why? Yeah. So, I mean, that was a sad state of hey, shush. You guys want to see my dog? Maybe I should show you my dog. This is a little one. This is Bailey, and she's an adorable. Oh, you want to get up there? What's going on? She wants to go out. She has a cat. We have a cat, and that cat and that dog are besties. It's pretty cool, and kind of weird too. Okay, so let me see if I have any notes here. Let's go to, okay, so I think I finished all this one. Conclusory statements. I don't think Pomplin did conclusory statements. I think he did a good job of laying out the facts. So it's going to fail on many points. One is this. And they literally mentioned Scarface at one point. They mentioned Sheetrock. It's crazy. And then they said, Nick is an actor. I don't believe he's an actor. It's a performance. I mean, like, look, people have said these things about, and actually this was, I think it's a defense of people have done this, Maddow, when they get sued, right? Even Alex Jones, I'm putting on a performance. Okay. I get that, but I don't believe Nick has been saying, and this is, Nick didn't say it in his stuff, right? You would have thought that would have come out right away, which is I'm an actor. I do these fake performances all the time. I lost weight for this movie. There's a dramatization of my life. Darth Hideous. What all these catalogs fail to realize is all the cocaine was actually property of the Sinaloa cartel kingpin that lives in the house. Yes, The 9-year-old. Okay, that pretty pup. Yeah, she's pretty good. Why indeed Wickney? Why? Okay, people. So I think that's where we're at with the Nick stuff. He's got a settlement conference that he pushed off. Maybe he's like, he read this, he read this, and he's like, whoa, an actor. Okay. Why don't we put off my settlement conference until after this? Because if she gets the warrant kicked out, maybe I have a chance. No, you didn't win the warrant. You didn't do this motion, whatever this motion is. You did a Frank's challenge, a Frank's hearing. Okay, so Aaron swatting, likely not the case. Now, uncivil law had a comment here about Aaron's case, and I thought it was fascinating, and then we'll do my little bit of analysis with it.
Adios, arrivederci.
Okay, sorry. Sorry. So then I'll do my, where is it at here? Browser. Why am I not showing? Maybe I have to do it on this one. Okay, there we go. Okay, so here is uncivil law. Let's make him a little bigger. I don't mean that in a bad way there, Kurt, at all, but let's. I want to be able to see you a little bit bigger. Oops, not that way. There we go. We'll do that. Okay, let's see what Kurt has to say here about Aaron's case. Remember, it was revenge porn. What did he have to say about it?
Aaron's case is likely.
And I'm getting an echo. So let me just see if I can do a X. Maybe this will work.
To not go forward.
Nope, it's still an echo. I don't know if you guys hear an echo, but I do. Oh, I think I figured it out. Okay. No, I think I did.
The case against Aaron is not likely to go forward. The principal witness is out of state. And based on my understanding, has made no particular indication that he's willing to travel back for the purpose of trial. So I think Aaron's case is, not going to go anywhere. Aaron is going to ask for speedy trial. The state's not going to be able to make it because they are unable to secure their witness, and the case is going to be dismissed. That seems like the most plausible resolution for Aaron.
Okay, and dead air, Kurt. Come on, you can do it. Dead air. Don't give me dead air. You got more to say?
Aaron already waived speedy. He could invoke it, though. That's not necessarily like a one-time thing, by the way. You can invoke it at a later time.
I don't know if that's true or not. Then why do they call it waiving?
So, he could change his mind. And would start the clock whenever he invokes it.
Okay. Okay, so there is that. However, y'alls, I found something that was a little different. Okay, and let's see if I can find my tweet here. There we go. Let's see if we can bring this back out. So here is what I replied to. However, the Minnesota court ruled in 2023 that a defendant's right to confront witnesses face-to-face was not violated when a law enforcement agent testified via remote technology. You have your right to confront the witnesses, or your accusers. Assuming this wasn't a temporary emergency ruling for COVID, the state could compel Gino to testify remotely. It happens all the time in other states, and so and if you remember Johnny Depp, right? We had that trial. Alex Jones, a lot of those are civil, but there's a lot of testimony that's taken place via remote, dial in at Zoom as an example, and they've had their initial hearings that way. Now, I'm just putting this into context for cases that I do, which is, and if the Minnesota courts already indicated this for a criminal aspect, which was fine, then I'm sure it would be something. So Gino's not in the state; he doesn't want to travel there. Fine, but the DA can subpoena him to be a witness and have him testify via remote if he doesn't want to show up in person, right? Or if you do subpoena someone to be there and then they don't show up, Okay, well, then they're now in contempt of court, so you've got problems. What the DA needs to decide is whether this is what they want to do, right? Or you file a motion to the court and you're saying, hey, this person's unavailable. I want them to be available, and have them appear remote. Now, the judge has got to make that determination as to why that's the case, and they'd be like, hey, we can't get him here, and maybe the judge is going to force them to bring him. I don't know. The point I'm getting at is, I don't think that what Kurt says is dispositive. So you could bring him in remote. You can have this. You can still have this case go on. Sorry, Aaron, don't mean to burst your bubble, but it is possible for this to still go forward in this case. And do I care? Not really. So there you go. Last thing I'm going to do, I'm going to read this article here it had to do with Robert Barnes, because I got into it a little bit last week, and let's see if anybody else is here. Kurt is dead air champ. Yeah. How can they compel him? He's in another state. Okay. Compelling doesn't necessarily well, you have a few options, which is, and it may not work, right? Which is you send him a subpoena to be in court. Okay, if he doesn't show up, then they can issue a warrant. Now, they did that to Ethan Ralph, a warrant that's actually all states. I don't know that they would necessarily do that, right? But, if you have a subpoena to appear in court, you damn well better do it. Otherwise, he might not want to be going back to Minnesota. Is this something now he's involved in where he's just going to refuse to do it? I don't know. All I'm telling you is just there's options, okay? And is the court going to exude itself to the point where it wants to really put these people through this? I don't know. I mean, think there are issues where, and this is a little bit more touchy. Let's say you have a domestic violence issue, and the DA wants to bring charges, and let's say it's a woman that's been abused, and she's like, I'm not going to testify. Okay, you can compel her to show up. You can't compel her to testify. Okay, I mean, you can try to. The judges do have options, which is I'm going to put you in jail until you actually testify. I mean, these are things, but you're right. He's not in the state. Gino's not in the state, but you can, you can send him a link to testify for, my son, as an example, his car got stolen and, last year, and he ended up getting it back, and they caught the lady, and she'd done this a bunch of times, and she's, wasted on drugs and whatnot. So he's zoomed in multiple times because it's up in Oregon, Portland, and now he does live up there. But this was over the summer and whatnot. This last year, and he was actually with us in South Carolina, and he was having to call in, zooming into the DA, to court appearance to testify. You can do it. It's not beyond the realm of possibilities. They can ask. Yes, they can. Ethan Ralph is going to hold out until he has medical issue force him back. And I saw he wrote a letter to the judge basically saying, look, you got to quash this warrant because I can't come back. If I come back, you're going to arrest me. I need to come back. I need to take care of my cats. He literally said that. I got to come back and I want to take care of my cats. And if you don't quash this warrant, I'm going to have a lot of trouble coming back. And I'm like, okay, but that's what they want you to do, but it is like, look, I'll come back and I'll take care of everything. I just, I don't want to be arrested. Barnes, LOL. Yes, let's talk about Barnes. Partly because I got some shit last week, and maybe I'll look at that. So this is good old Barnes here. There's a lot of good stuff here, but let's go right to the meat of stuff. The complaint filed by Barnes accuses Senator Warren Hallen, Representative Deb Haaland, CNN's Anna Navarro, the New York Times reporter Maggie Haberman, comedian Kathy Griffin, ABC analyst Matthew Dowd, and activist Sean King, among others, of defaming Covington students. One of the liberal personalities named in the complaint is former CNN host Reza Aslan, who tweeted the image of Sandman with the caption, honest question, have you ever seen a more punchable face than this kid's? These three, maybe. Barnes, who does not represent Sandman, claimed that his clients were defamed by Aslan's tweet, and that caused things to get particularly bizarre on Thursday. I would like to see it. Now, this is what I've said the whole time, which is no one cares about, sorry, I know their parents do, and they do, but no one cares about Covington kids, okay? You only care about Sandman. He was there in the middle. He's the one that was defamed. And you can say whatever you want about those other kids. It's not really much of anything compared to, and what did he get out of this? I would be baffled if Robert Barnes got anything out of this lawsuit for the, quote, Covington kids. Because when you say Covington kids, you really think of Sandman. Sandman took to Twitter and blasted Barnes in a series of scathing tweets, accusing the lawyer representing his classmates of using his name and image to drum up attention for his own case. So this is what I was saying last week. And I know you think I'm being bizarre with my anger towards Robert Barnes. And I'm going to play, before that, there was one other person, and this person had made comments about Robert Barnes. Why are you doing personal? And I've expressed why I've gone personal against Barnes. But here is, let's see if I could find this here. This is Barnes himself and the reason why.
Well, we'll deal with it with legal mindset.
Hang on.
If you come after me and libel me repeatedly, as well as flood my chats and the people that are part of our community with what's known as toxic Twitter, which is what he was doing, then maybe I'll take the time to ask and research why it is you suddenly left the state of Florida and went to Southeast Asia as a single man. And maybe when I do, I'll find that you chose the town in Thailand most infamous for one thing. You know what that thing it's most infamous for? The town Legal Mindset chose to leave Florida to live in Thailand and to legally provide services to other, let's say, similarly situated individuals, is a town world famous for which documentaries have been made for child prostitution.
Okay, so first of all, this is the kind of the reason why. So I haven't seen anything, and Barnes, by the way, talking about conclusory statements, you're libeling me, Legal Mindset. Why don't you say what he said? But honestly, the stuff that how this whole started out was just like, I don't think Barnes is on the level with his analysis that, Nick Rekieta is going to get off. And what I mean by that is not that April's under his desk, but that the cops aren't going to let him out, early, or the DA is going to drop the charges. That's what we mean, Barnes. And we said your analysis, I didn't believe it. It was like, you're trying to make this into a political case with a complete piece of shit. Not just Viva, but Nick Rekieta, a complete piece of shit, and you're going to have a tough time because it looks like the police didn't make all these lies that you said that they did. So you didn't like that, and then you start to say these kind of things about Legal Mindset. You said awful things about Sean. You said awful things about Kurt, Nate. Why not me? Oh, you blocked me at one point.
That's where he chose to live. I wonder if that's a coincidence. What motivated that shift? But if these people are going to, do this kind of thing, well, all right, all bets are off. I wouldn't recommend it personally, just as a matter of professional strategy. Well,
Okay, so and look, I get some of this. By the way, this is one of the great comments. My anonymous clients' lives have been changed forever. That is such a good analysis. These two clowns, Fry is no better. No, he's not, and the reason he's not is because I don't think. Him especially. I mean, it's I guess it's a grifting thing, which is you take so harsh your team that you can't do. It's everything's in that political mindset, and I don't even know if he was ever an attorney. I guess he was. Honestly, I do get the vibe that mindset, especially when he's all over the VTuber stuff too. Well, you can say you get that feeling, but that's not what Barnes said. Okay, Rare Barnes been there. Okay, anyway. Any of the dudes who flee the West for Asia are sus. I don't know about that's true. Yeah, Barnes is way creepier than Legal Mindset. All I'm saying is whether you think that Barnes is making truthful statements or not. He hasn't brought any evidence to that, but he's skipped the reservation. He skipped off to making these kind of comments rather than just sticking to the case itself. Why? Because he had no grounds. He had no grounds. He had no Daryl Brooks in this case. He was legal analysis was about where Brooks was.
Well, we'll deal with it with legal minds.
I didn't want to talk to you anymore. Okay, let's go back to this. Sandman said, Barnes, would you like to explain why you're suing for me without my permission? You blocked my lawyers on Twitter and now claim you're suing over Reza Aslan's tweet. Retract and stop lying to the public. Yes, Barnes can claim all he wants that he's filed on my behalf of the Covingtons, but we both know that isn't true. Okay, that's an interesting tweet. that's not me saying that he's not filed on behalf of the Covington kids. That's Nick Sandman now saying that. So if I'm deceitful, this guy is really, this tweet references only one kid, and I take up a majority of the picture. The article he even linked, now deleted, stated this. As a lawyer, Barnes should know that he has no claim in this case either. Not a single judge on the planet would be convinced that this kid's is directed at a different singular kid with evidence to show. Just can't believe it. Okay. Would you like to explain why you're suing for me without my permission? You've blocked me. We just said that. Barnes can claim. Okay. My position since January 18th, 2019 has been clear. I will not be used by anyone in the media outlet to gain clicks, money, or attention. I'm getting clicks, people. This is just that, Sandman added. Some critics rushed to Barnes' defense, noting he has long claimed to represent Sandman's peers, not Sandman himself. Many pointed to a tweet Barnes sent earlier in the day that specifically said Sandman was not his client. All Covington boys I represent retain anonymity as John Doe's. Nick Sandman, who went, and by the way, this is why you know it's bullshit, right? Which is, and it's for him. What he's trying to do here, he's sending basically a letter to he's not filing. He said he's making claims. I understand they're minors, but how are you going to show damages in defamation if you don't say who these people are, right? Part of that whole breakdown would have to be that there was loss of income, or I'm shamed and I can't get a job, or I'm ostracized at school, but no one knows who you are and your name's not out there. So now it is a little bit odd because you're not even a public figure. So when public figures are going after private individuals, it is an easier standard to get, but it's also just a little bit iffy. A key precedent we seek, okay, not my client. The reason to protect their privacy is the threats they already faced. A key precedent we seek. You should not forfeit your privacy to sue for invasion of privacy. Okay. Barnes' 53-page complaint, does not mention Sandman by name. When asked by Fox on Thursday about the CNN settlement meant for his clients, he responded by saying, I do not represent Nick Sandman, before offering a quote. He told Fox News that the cases, quote, shape the future of media and the social media age, and the reporters need to be aware of CNN's decision. Early journalists should pay attention to these cases to understand how their stories impact ordinary people and how they can be individually and institutionally responsible when they get it wrong, he said. The Covington cases show how dangerous social media lynch mobs can be when led by prominent media personalities, and the CNN statements show no one is immune from accountability. Todd McMurtry, a member of Sandman's legal team, came to the client's defense. Robert Barnes keeps trying to suggest he represents Nick Sandman. He does not. Barnes long ago blocked me, so I cannot ID him in this tweet, he wrote. Famed attorney Lynn Wood, who also represented Sandman, then echoed McMurtry in the series of tweets himself. Nick Sandman has many legitimate defamation cases remaining for the resolution through litigation. McMurtry and I prefer to focus on those matters and not be forced to take legal action against another lawyer. But Robert E. Barnes crosses the line with his claims about Nicholas. Barnes has previously warned to stop publicly suggesting or stating that he represents Nick. In response, Barnes blocked Todd McMurtry and me on Twitter. Why would you do that? That is sus. That's more sus than someone moving to Asia. Barnes apparently cannot control his desire to garner publicity by falsely using Nick's name. For those who can access Barnes and support his legal efforts for others, please remind him that he cannot block a formal demand letter, a civil complaint, or an ethics complaint. I hope he finally gets the message. Shit. Barnes does not cease publishing and then correct his prior statements. Nicholas's attorneys are fully prepared to take legal action against him. So Barnes can take the easy way, or he will get out the hard way. We will sue him. His choice. Barnes declined to comment when asked about criticism from Sandman and his legal team. Wood and McMurtry did not immediately respond to Fox News for additional comment. Wow, people. Full chat. Let's see if Barnes is way creepier. Yep, all ad hominems. Legal. Okay, wait. I don't think he's a pedo. Only a suspected or escaped pedo, not a confirmed one. He's an ambulance chaser. That's not an ambulance chasing. He's watching the ambulance go by and then asking the passersby if it hurt their ears. Yeah, this is a little odd. All right, well, look, I hope we broke things down. I always say this. I'm going to get to the mailbag, but I don't think I'm going to. I do like to respond to those. I don't even look at the comments. I know the Barnes one, it's like 2,000 views on that, which, it's a big one for me. We don't get huge views. So I like to respond to them on air rather than just myself. It's more enjoyable that way, but I think we're going to head out tonight. I've got to go eat. My wife got me some burgers, or a burger, a single burger. And hopefully it's good. It's in and out. I hope you guys like that. I like it. So we're going to go out with a video. I think it's Nick. Once again, thank you, everybody. We will talk to you next week. 5:15, 8:15. I had some other items that we were going to go through. Maybe I'll even throw up I can't do it this weekend. My wife and I are going to go. It's our anniversary tomorrow. 12 years. Love that lady. We're going to go on a little vacation on the coast, although I'm going to work from there. And I'm not going to do podcasts about that. I was going to do this issue because I was in a space and I didn't really participate because it frustrated me. And it was about two quick. You know what? Let's do these here. Hope you guys have a little time. These are 2 comments real quick, and then we will possibly get over this. Okay, so this is 2 people had comments. This is from a Spaces.
Financial relief
I hope you can do that.
from what they think they have legislative authority to do already.
Trump is going to have to do something else because this has already been adjudicated.
Someone asked if maybe Trump's what he can do, because some of these cities are talking about being sanctuary cities. Maybe you just cut off the federal funding. Okay, so this guy, this libertarian something of Colorado or Orange County or whatever, I think it was Orange County, came in and made these comments.
Under the federal, when they tried to restrict the speed limits and said, if you've got to have we're going to restrict your highway funds if you don't lower the drinking age. And so that's already been adjudicated, and the federal government did not actually withhold any money for states that left their drinking age at 18.
I haven't heard anything about them. It's just all talk of them just coming in and, starting to deport people on a list. So I'd like to hear more of a detailed plan on what they're going to do in terms of the budget.
Okay, I'm going to stop there. So he talks about that case, which is, first of all, no, that's something you famously learned about in law school, which is the federal government can put conditions on money. And that, matter of fact, whether it was drinking, it's the famous case is South Dakota v. Dole, landmark Supreme Court case. The court ruled that Congress can condition federal grants on state policies as long as the conditions are 1, unambiguous, 2, related to a valid national interest, serving a legitimate federal goal, not unconstitutional, not infringing upon a state's rights or violating the Constitution, 4, not coercive, not unduly pressuring states to adopt a particular policy, and serving the welfare, the general welfare, acting in a legitimate federal interest. That's why the speed limits nationally were 55 for a long time. You guys may be too young to know that, but they were, and it was part of this drinking age. It was part of other things. It was federal funds that went to the states, and they kept the speed limit at 55, except for Nevada. I don't think they were taking funds at that point, but you can definitely do it. And then Trump, in his first go around, actually was sued by, I think it was San Francisco and also New York, because he was threatening or was withholding federal funds based on immigration issues. And that was going up to the Supreme Court, and they pulled it from the docket as it's in the Supreme Court because he lost the general election in 2020. And so they pulled that and they said, well, it's not going to be an issue because Joe Biden's, of course, going to do whatever he wants. So that right there is, this gentleman was wrong. And you should know that perhaps, Trump can, I think it was, he won in New York and lost in San Francisco. So the Ninth Circuit got him. I think the third said he could, and the ninth was saying no. And so then it was all going up to the Supreme Court, and they were going to make this case for it again. And I think that's something that you can do. Last thing I'm going to play here. This was also an interesting comment that someone, someone talked, and it was about Nancy Pelosi. Take it away.
If anybody thinks that, this is not going to happen to your state, you're wrong. Today, like a couple of fun facts that perhaps people don't know. Like, so for example, Nancy Pelosi's seat in San Francisco, she actually never got voted in. If anybody doesn't know that, well, I'm here to share it. So there was a gentleman that was the, like our congressman, our representative that died, and he gave his constituency to his wife. And so Nancy Pelosi moved out here from Baltimore. Check out that if you can find the history, check it out. But anyways, so his wife became, or Nancy Pelosi became his wife's best friend. She died, and then she handed her whole constituency to Nancy Pelosi. So technically, Nancy Pelosi was never elected.
Financial relief.
I mean, we understand how.
Okay, so is that true? I heard that and I said, what? I know there's crazy shenanigans going on, but here's what I found out. Yes, she was from Baltimore, and this other lady was, Sala Burton was her name. She herself was elected during a special election featuring her previous incumbent's death, which was her husband. He died in 1987 from colon cancer. And then he died in 83, I think, and then he died later, and then so the seat was once again, but they held a special election for this Sala Burton. It wasn't handed. It could be handed. I mean, they've actually had that. I'm trying to remember the guy. He was a congressman or a senator, I think, from Pennsylvania. He dies, and they just let his wife take the seat. Now it's a little bit different. This was not quite the case. This Sala Burton she went through a special election, and she actually won. And then Nancy Pelosi comes along, and Nancy Pelosi goes through a special election herself. She does not get, she gets 63% in a runoff. So she has initial primary. She doesn't get 50%, but they make votes, and the Democrats got second place, and then they did a runoff, and then she ended up winning that. So this, I don't know what, I mean, look, people say crazy shit, and this is the kind of stuff I like to kind of push back on sometimes, like the Sandman stuff, because you just never know what's going on. It's crazy, and I prefer to have clarity than someone just saying bullshit like that. Oh, we got $10 in here. Okay, we talked about that. JC to say goodbye to. Yeah, JC, I don't know where JC is. JC is vacationing or Thanksgiving somewhere. Thanks for the show. Thanks, Charles K. I really appreciate the $10 there. How did the wife die? Oh, that's a great question. Let's take a look here. Sala Burton. Oh, she herself was elected during the special election following her previous encounter. She died from colon cancer. There you go. Was it Ethan Ralph is a real victim? He's trapped in Mexico forever. Yes, he did. Was it a hammer attack? Love you guys. And with that, I think we are going to go out. Thanks, Hubbleson, for that great comment. We will be, there we go. There we go. Okay, so we're going to be out. Till next week, everybody. Appreciate you hanging out. See ya. Have a great weekend. Bye.
Adios, arrivederci, au revoir. Take one, 5 cameras.
Why would you do this? Why now? Why is my camera so on? Trying to shut the show down. Like, oh, we'll play the credits. No. What we'll do is we'll sit here. Guys.
Okay, everybody, that's a wrap.
Here's